Hey, want to welcome everyone. I used to try to get that kind of effect. Sounds like start of B-52s. So what do you think? I like this. Okay, we'll try this again. Oh, I know. Okay.
One, two, test, 1, 2.
Check.
Test 1, 2. Test 1 2. Testing 1 2 2 something. Is the Skype? Test 1 2. Test 1 2. Test 1 2. Testing 1 2. Test 1 2. Test 1 2. That's not. Is that better? Testing 1 2 3.
Check, 1 2. Don't touch anything. Okay, thank you, everyone, for bearing with us on that. Before we begin this afternoon's meeting, I'd like for everyone to please bow for a moment of silent reflection, and I think it's appropriate to remember the folks that sacrificed their lives in 9/11, and so we'll take a few minutes of silence. Thank you. Mr. Minges.
Good afternoon, Mr. Chairman, Commissioners. Our next agenda meeting, our next Commission business meeting is scheduled for Wednesday, September 25th, 2019 at 2 o'clock.
Okay, September 25th, Wednesday.
We have one supplemental item on today's agenda. That's docket number 2019-291S. This matter concerns more sewers notice to customers regarding its sale and transfer to the Spartanburg Sanitary Sewer District.
Mr. Chairman.
Commissioner Williams.
Mr. Chairman, I move that we grant the joint applicant's request that they be allowed to provide notice to affected customers by the mail. I want to note for the record that the Office of Regulatory Staff does not object to this notice method.
Thank you. You've heard Commissioner Williams' motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
Turning to our utilities agenda, item number 1, docket number 2019-283C. We have an interconnection agreement.
Mr. Chairman.
Commissioner Howard.
Chairman, I move we approve the interconnection agreement between SCS Wireless LLC and Bell South Communications LLC doing business at AT&T South Carolina. According to the party, that agreement allows for the interconnection of their networks and the unbundling of specific network elements and or the resale of telecommunication services. So moved, Mr. Chairman.
Thank you. Commissioner Howard, you meant CSC, right? Was that CSC Wireless?
CSC Wireless.
Okay. Thank you. You've heard Commissioner Howard's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
Item number 2, docket numbers 1996-364C and 2007-155C. This matter concerns Mitel Cloud Services' request to cancel its certificate and withdraw its tariffs.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that we approve the request of Mitel Cloud Services Incorporated to cancel its certificates and withdraw tariffs. The Office of Regulatory Staff has reviewed this matter and does not object to Mitel's request. According to ORS, Mitel has verified that all of their customers in South Carolina are nomadic VoIP customers and that none are or will be served using resold or leased local exchange competitor lines. Mitel has registered as a VoIP provider and will contribute to the State Universal Service Fund and dual-party relay fund as required by law. The South Carolina Telephone Coalition also has no objection to Mitel's request. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
Item number 3, docket number 2019-14C. This item concerns the certification of the use of high-cost universal service funds with the Federal Communications Commission and the Universal Service Administrative Company.
Mr. Chairman,
Commissioner Belzer.
I move that we direct staff to file high-cost certification for those carriers properly certifying appropriate use of high-cost funds and certifying that they will use high-cost funds appropriately in 2020. I so move.
Thank you. You've heard Commissioner Belzer's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
Item number 4, docket number 2019-189WS. JCAB Utilities is requesting to extend the waivers ruled on by order number 2019-507.
Mr. Chairman,
Commissioner Urban.
on July 11, 2019, the Commission awarded by order number 2019-507 that approved JACABB Utilities request for waivers of certain requirements necessary for it to supply water and sewer service for multifamily student apartments in the Rosewood at Clemson Development. These waivers were to last until August 12, 2019, and were for the following. 1, the construction permit from the South Carolina Department of Health and Environmental Control approving the engineering plans and specifications. 2, statement by a professional engineer that the system was built and installed according to plans and specifications on file with the Commission and furnish adequate service for the area to be used. And 3, a letter from the South Carolina Department of Health and Environmental Control approving the system for operation. As you recall, however, on July 30th, 2019, the petitioner informed the Commission that it would not be able to comply with the deadlines for waivers as noted in our earlier order. In its letter, the petitioner states it understands that the transfer of the system is conditioned upon approval by both the Commission and the South Carolina Department of Health and Environmental Control, but that it has no control over when the construction will be completed and when DHEC will issue the approval to place the system into operation. Therefore, the petitioner seeks to extend the temporary waiver until DHEC issues approval to place the system into operation with the understanding that the approval from both the Commission and DHEC are required before the system can be operational and before any charges for water and sewer can be made to the developer and or tenants of the apartments. Additionally, the utility assures the Commission that it will provide a letter from a professional engineer as soon as construction is complete, and that the professional engineer has issued the letter. The Office of Regulatory Staff has stated it does not object to extending the temporary waiver, and on August 26, 2019, DHEC issued its wastewater construction permit. Therefore, I move that we approve the petitioner's request to extend the temporary waivers until construction of the system is completed and the DHEC certification has been approved for operation. However, this information and certification letter from an engineer must be provided to the Commission before we issue our final approval to operate. Further, as stated in our previous directive, I move that we grant this request with the understanding that the appropriateness and the sufficiency of the company's current financial security in light of this proposed expansion is not being ruled upon at this time by granting this waiver request. Additionally, as already ruled upon by this Commission, the question of appropriateness and sufficiency of the company's current financial security is reserved and will be explored as part of the Commission's ongoing evaluation of the application. So moved.
Thank you. You've heard Commissioner Urban's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Item number 5, docket number 1997-294E. We have a request for approval of contract amendments.
Mr. Chairman,
Mr. Belzer.
I I move that we approve the Sixth and Seventh Amendments to the contract between Owen Electric Steel of South Carolina, doing business as CMC Steel Company, South Carolina, and Dominion Energy, South Carolina Incorporated, and grant the request for confidential treatment of the Sixth Amendment. Dominion asserts that certain provisions of the Sixth Amendment are competitively sensitive. ORS recommends approval of the filing. I so move.
Thank you. You've heard Commissioner Belser's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. Motion carries. Thank you.
Item number 6, docket number 2019-260E. This matter concerns the complaint of Charles Hawkins against Duke Energy Carolinas.
Mr. Chairman,
Commissioner Howard.
the chairman's background, this is the 4th complaint filed by Mr. Hawkins in the past 12 months. 3 prior complaints were each dismissed. On Monday, September the 9th, 2019, Mr. Hawkins filed an additional statement related to this matter, an apparent response to Duke's motion to dismiss, and attached an affidavit submitted by Duke employee Pam Housey. Pursuant to Commission Regulation 103-829A, Mr. Hawkins' response to DHEC's motion to dismiss was due no later than August the 29th, 2019, 10 days following the service of the motion. Even if the Commission were to consider Mr. Hawkins out-of-time filing, it does not change the relief Mr. Hawkins seeks in this newest complaint. In the complaint, Mr. Hawkins seeks replacement of Ms. Housey as his account representative and seeks for the Commission to set up a payment arrangement so I can maximize my opportunity with the assistance agency. Mr. Hawkins failed to specify any violation of the Commission rules or regulations by the utility for which relief can be granted, and his request for a payment arrangement has already been provided numerous times over the past year. I move we dismiss Mr. Hawkins' complaint. So move, Mr. Chairman.
Thank you. You've heard Commissioner Howard's motion. Are there questions or comments?
Mr. Chairman,
Commissioner Belser.
I think that all of us are empathetic and sympathize with any customer who is having financial difficulties in paying their bills. However, sympathy cannot replace the rules and regulations, and I am in agreement with the motion. I'm sorry that they're having such a hard time, but there has been no alleged violation of any of the Commission's rules, regulations, and statutes, and we just can't grant relief because we feel sorry for them. And I'm sorry for that, but it's just the way it is. Thank you.
Thank you. Any other questions or comments? If not, all in favor, please say aye. All opposed, no. Motion carries. Thank you.
Chairman, items number 7 through 14 are petitions to intervene by the following entities that can be taken together. Item 7, docket 2019-262E, Nucor Steel, South Carolina. Item 8, docket 2019-239E, the NAACP, South Carolina Coastal Conservation League, and Southern Alliance for Clean Energy. Item 9, docket 224E, Johnson Development, 2019-225, and 226Es, Johnson Development, and the rest are through item 14.
Chairman.
Commissioner Hamilton.
Chairman, I would move that we grant the petitions to intervene identified by Mr. Menges in items 7 through 14. So move, Mr. Chair.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. Motion carries. Thank you.
Mr. Chairman, item number 15, docket 2019-59A. This matter concerns the proposed regulation of 103-817.1.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, you may recall that Chief Clerk Administrator Jocelyn Boyd did a presentation on this last week. Regulation 103-817.1, when it becomes effective, covers the procedures for electronic service of legal filings submitted to the Commission by external stakeholders. The proposed regulation closely follows the South Carolina Supreme Court's electronic filing policies and guidelines, specifically Guideline Number 4. Mr. Chairman, I move that we approve this proposed regulation.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? If not, all in favor, please say aye. All opposed, no. The motion carries. Thank you.
Mr. Chairman, on our transportation agenda, items number 1 and 2 are new applications that can be taken together. Item number 1, docket number 2019-288T is Precious Adult Daycare Incorporated. And item number 2, docket 2019-293T, South Carolina Family, or SC Families Transport, LLC.
Mr. Chairman.
Commissioner Hamilton.
Mr. Chairman, I would move that we approve the new applications in the dockets identified by Mr. Menges in items 1 and 2. So move, Mr. Chair.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? If not, all in favor, please say aye. All opposed, no. The motion carries. Thank you.
Item number 3, docket number 2018-353T. We have a request for an extension of time.
Mr. Chairman,
Commissioner Belser.
Curtis Enterprises of Darlington Incorporated, doing business as Samco Medical Transportation, is seeking an extension of time until March the 4th, 2020 to comply with Commission rules and regulations. However, he received his initial order granting certification on December 4th, 2018, and he has previously requested and received an extension of time in March of this year. I'm concerned with the Commission granting an extension to authorize him to begin operations that is 12 months past the date of the initial order approving certification. I therefore move that the Commission allow a further extension until December 4th, 2019 for Curtis Enterprises of Darlington, Inc., doing business as Samco Medical Transportation, to comply with all rules and regulations necessary to begin operations. If Curtis Enterprises of Darlington, doing business as Samco Medical Transportation, fails to come into compliance with all rules and regulations for a certificate to be issued before December 4th, 2019, then authority granted under order number 2018-748, which is dated December 4th, 2018, is canceled, and a new application must be filed to receive certification. I so move.
Thank you. You've heard Commissioner Belser's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
And item number 4, docket number 2019-218T. We have a request for an extension of time.
Mr. Chairman.
Commissioner Williams.
Mr. Chairman, I move that we grant the request of Compassion Hearts Transportation, LLC, for an extension of time to comply with Commission rules and regulations. Mr. Chairman, I move that extension is to December 11th, 2019. So move, Mr. Chairman.
Thank you. You've heard Commissioner Williams' motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. Motion carries. Thank you.
Item number 5, docket number 2019-256T. We have a request for an extension of time.
Mr. Chairman,
Commissioner Irvin.
I move that we grant the request of Erskine J. Carter, doing business as Carter Transit, for an extension of time until December 2019 to comply with Commission rules and regulations. So move.
Thank you. You heard Commissioner Irvin's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Item number 6, docket number 2019-145T is a request for an extension of time.
Mr. Chairman.
Commissioner Howard.
Chairman, I move we grant Andrew Simon, Jr., DBA Distinctive Limousine Services, request for an extension of time until October the 30th, 2019, to comply with Commission rules and regulations. So move, Mr. Chairman.
Thank you. You've heard Commissioner Howard's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
And item number 7, docket 2019-160T, we have a request for an extension of time.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that we grant the request of Reliable Care LLC until January 11th, 2020, to comply with Commission rules and regulations.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries.
Item number 8, docket numbers 2017-176T and 2019-270T is a request to cancel.
Mr. Chairman,
Commissioner Irvin.
I move that we grant the request of Club Horizon of Charleston LLC to cancel Class C non-emergency certificate number 9271. So moved.
Thank you. You've heard Commissioner Irvin's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries.
Item number 9, docket 2016-406T and 2019-271T, we have a request to cancel.
Mr. Chairman,
Commissioner Williams.
I move that we grant the request of C&J Tours of Camden LLC to cancel Class C certificate number 9222. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Williams' motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries.
And item number 10, docket number 2017-372T is a request to amend.
Mr. Chairman.
Commissioner Hamilton.
Chairman, I move that we grant the request of Madison Transport LLC to amend Class C non-emergency certificate number 9320 to read Jordan Transportation LLC. So move, Mr. Chair.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? Not all in favor, please say aye. All opposed, no. And the motion carries. Thank you.
Mr. Chairman, that concludes the transportation agenda. I'd like to just turn briefly back to the utilities agenda to clarify items 12, 13, and 14. Item 12 is docket 2019-224E. That's the request to intervene by the South Carolina Coastal Conservation League, the Southern Alliance for Clean Energy, and Upstate Forever. Item 13 is docket 2019-225E. That's also a petition intervened by the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, and Upstate Forever. And item number 14, docket 2019-226E. That's the South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy, but does not include Upstate and Forever. I just wanted to clarify that.
Okay. Anything else we need to do with that then?
We don't.
Just that clarifications?
Yes, sir.
Okay.
We do have one administrative agenda item. This item is the presentation of Cindy Brown Miller, Esquire, regarding Act 62.
Thank you. Welcome, Ms. Miller. We're glad to have you here today.
I'm Cindy Miller of Cindy Miller LLC, and I'm grateful for the opportunity to do some work for the South Carolina Commission. I wanted to tell you a little bit about myself, and then I'll go into the work that I've been doing. I worked at the Florida Public Service Commission around 30 years, and then I became a consultant. I was an attorney at the commission, primarily working on rulemakings and monitoring of Federal Energy Regulatory Commission matters. The rulemakings included ones on avoided cost, renewable portfolio standard, and net metering. For a couple of years, I also headed a division that worked on legislative matters and commission policy issues. I also worked on ethics matters and declaratory statements. Before working at the commission, I worked as a management analyst at the Office of Management and Budget in Washington, D.C., and I was a presidential management intern at the Office of Secretary of Defense. Also, I worked for a law firm for a while, which is now Greenberg Traurig, and I worked in the Florida legislature and was Inspector General for the Florida Department of Management Services. My law degree is from University of Florida, and I have a master's in public administration from Florida State University. And now that I'm working as a consultant in the private sector, I'm primarily doing research. So I want to talk a little bit about this current project that I've been working on. Basically, I'm doing regional research for generic proceedings and rulemakings on 5 issues. And the first 2 issues I have been researching are from Act 62, all of this is from Act 62, on integrated resource plans and also interconnection. And then in the future, the areas for research are competitive procurement of energy and capacity from renewable facilities, energy metering, and issues relating to lease generation for electric utilities. So what I have been doing, and I would really appreciate any guidance that you want to give me today, is I have been researching regulations and orders on integrated resource plans and interconnection in the following states: North Carolina, Virginia, Florida, and Georgia. And I've also gone ahead and contacted key staff to make sure that I'm reviewing the right materials. By the way, there's voluminous amounts of materials here. So at this time, what I have is a 20-page draft of what I've found, and I have attempted to summarize the precise rules and orders and laws and not color what I have found and not make any recommendations. I believe this is a strength. In addition, I have started to work on charts in which you could quickly compare the different states on how they've approached these 2 topics, integrated resource plans and interconnection. And this is going to be harder to do. I'm really hoping to finish this on these 2 issues in the next few weeks. But I hope those charts will work, because I think they will really help you a lot if they do work. And if there are any areas that you specifically want me to list as criteria, well, how do these other states handle these criteria, then that would be helpful. For example, on interconnection, there's many different approaches, and most of them seem to have different tiers of interconnection depending on the level of energy and capacity involved. And also there's issues on how much you charge for insurance, how much you charge for a surety bond, how long the utility has to respond to an interconnection request. So there are many different things that the states have addressed. Let's see. I want to talk a little bit too about how in your new law there are different approaches on each of these 5 topics. Some of them, for example, require a rulemaking, and some of them instead say you may do something, and some of them say you are authorized to do something. So I know how those terms mean in Florida, but they may mean something different here, but I did want to point that out. On interconnection, I found the North Carolina Commission process very interesting. They had a very lengthy proceeding, actually. It was over a couple of years. And they had a stakeholder process in which they hired a company to facilitate that, called Advanced Energy. And then what all their stakeholders did was they submitted a red line stipulated version of what they wanted interconnection to look like. not all the parties agreed to that, so there were still some opposition. But in general, the commission found that red line stipulated version really helpful, and then they just made some changes to it. Let's see. Some of the issues that have been addressed in the interconnection area are also like criteria about a disconnect switch and insurance requirements. I mentioned a couple of those. On integrated resource plans, the commission is authorized to promulgate regulations, and then Act 62 lays out certain areas. As I looked at integrated resource plans in surrounding states, I saw there are lots of issues in that too. Some of them make them binding on future proceedings that you have. Some of them make them very clearly non-binding. And also, there's, again, different ways that states have handled this. Some of them do it clearly through going a rulemaking process, and others have gone more with an order and a workshop and then a report. The other topics that are in the contract that I have are on net energy metering, exemptions as to electric utilities, and also competitive procurement of energy and capacity. So that's kind of gives you a little bit of a summary of what I've been doing. And it's nice to actually be here and see you all because I want to make sure that I'm making a valuable product for you.
Thank you, Ms. Miller. We appreciate you being here today and updating us on where you are in this research, and of course look forward to digesting the information that we're gonna be getting. I know we've talked about. I'm certainly opening it up for any questions that anyone has, and I know we're going to be looking at this and trying to making sure that that you have clarity on where that you were asking for on what you want to continue doing your research on. So if anybody has a question for Ms. Miller, we'll certainly entertain that now. And
Mr. Chairman.
Mr. Williams.
Thank you, Mr. Chairman. Good afternoon, Ms. Miller.
Good afternoon.
Good to see you again.
Thank you.
Appreciate all the work you've done on this matter to this point. Are you prepared to discuss the 5 rulemaking options you briefly brought up in your presentation? The mandatory requirements and the optional requirements?
I believe so, and what I've been focused on so far are the 2 topics: integrated resource plans and interconnection. And like I said, I have a draft of those topics, but if there's anything I can help on today, I'd be glad to.
You just mentioned there are 5 rulemaking requirements, some of them mandatory, some of them optional. I just wanted to hear you discuss that a little bit further.
Good. Yeah, I really noticed this when I went back through the language. I've done a lot of work in legislative matters, and so I began to wonder what this means here. For example, on interconnection, Section 58-27-460, paren A, paren 1, says you shall consider revisions to standards on interconnection. So that seems to me to have a mandate in there. On integrated resource plans, it says that you all are authorized to promulgate regulations to carry out that section, and that's in Section 58-37-40C. What I seem to see is some leeway on some and not on others. On net energy metering, it says that you shall open a generic docket, and that's the one by January 1, 2020. and that's section 58-40-20C. On competitive procurement of energy and capacity for renewables, this says in section 58-4120 that you're authorized. Let me make sure. This was when I caught myself. You know, when I came into the bright lights of this room, I caught an error in something I'd been working on. On competitive procurement of energy and capacity, that's right. Section 58-4120E says you are authorized to open a generic docket to create program for competitive procurement of energy and capacity from renewables by an electric utility within the utilities balancing area if the commission determines the action to be in the public interest. So that seems to give some leeway there. And then the last one is on the exemptions as to electric utilities relating to leased renewable generation. So that's section 58-27-2610. And in this one, it says the commission may promulgate regulations consistent with this section, interpreting the scope of some exemptions as to electrical utilities. So what struck me when I reviewed your Act 62 is what very major work there is to be done. So I thought it might help to see that there might be some areas that have a little bit of discretion.
Mr. Chairman, Ms. Miller, good to have you with us today.
Thank you.
Just a big picture view as it relates to Act 62. Have you been able to identify any other jurisdictions that have a similar act, or does this appear to be something unique to South Carolina?
My impression at this point is that it is a much more, careful word use, but that I have not seen a similar act. I know that when I first saw your act, I was struck by how recently I was on a Blue Ribbon Task Force on the Puerto Rican energy grid, and I was struck by how ambitious an agenda that law was and how ambitious an agenda this law is.
It seems to be kind of a paradigm shift. Would you agree with that in terms of how commissions looked at these issues in the past?
I haven't researched how South Carolina has addressed issues in the past, but from my perspective, yes, it did appear to be based on the legislative intent and some of the language put forth in it, a paradigm shift. I was struck also by some of the terms that were in there that I hadn't seen before in other laws, and new things on energy storage, and there's some phrase in there, I can't remember the exact wording. It's also something North Carolina has addressed. But yeah, I found these were, from my review of Florida law, quite new and cutting edge.
I would encourage you generally to look closely at North Carolina, since we do have two of the three dockets, I believe, span both jurisdictions, and it might be helpful to focus on what the North Carolina Commission has done regarding or relating to these matters. I realize their statutes would be different in some regards, but there are also, I'm sure, some similarities in how to approach these issues. So it might be helpful just to give us kind of a general history of what's transpired there. and perhaps some lessons learned there. I know there's been a good bit of activity. The other question I had was,
And if I could just
Yeah,
say on North Carolina, I just finished reviewing um, their interconnection docket. And yes, they just finished in July, I think it was June or July of this year, June 14th, 2019. And so I did find it really, really helpful. And it did address some of the things that you all are looking at. It did talk about energy storage. And since energy storage is relatively new, I was struck by the fact that they really addressed it in their order. And also I was struck by, I noticed in your statute, they have something on those, what's the terminology? Host capacity maps, let's see. Anyway, there was something very similar that they were looking at. So in fact, I already have in my paper so far 4 pages on the interconnection order in North Carolina, but that helps me. And also that it did take them quite a while though. If you think about it, I've thought about your timelines. They started May 15th, 2015. Issued an order starting all this. Well, actually, in May 2017, they convened this stakeholder process. So they've had a few years. But I will focus.
and it might be that you can look back on that history, kind of give us a chronological timeline,
Sounds good.
and perhaps you could also give us not necessarily, I don't want to say shortcuts, but if we had to condense that North Carolina timeline, what could be, condensed or shortened or eliminated, perhaps, to try to, move things along? Because there's, as you saw in the Act 62, we have some statutorily defined deadlines to meet certain objectives, and concerns all of us, I think, that we do it in a timely fashion.
I'd be glad to do that. And as I mentioned, I'd like to finish those 2 topics within the next couple of weeks or 3 weeks.
Right.
And
I think I like your approach by saying you're not going to make recommendations, specific recommendations on how case to be decided. You're just doing general research, and I think that's helpful to us because we have to understand, put it in some context. What are we dealing with, and how best to approach this assignment. And so it would be a great learning exercise for us, I think, to have you come in and maybe make a workshop presentation just to give us some guidance along those lines. And perhaps you can find best practices. I know NARUC has a legal staff. I'm sure you're familiar with NARUC. And they might be, they probably already have compiled some best practices or recommendations that we could learn from as it relates to integrated resource planning, because it's something that's changing constantly with the technological advances, and it would be a great help to us to have generally that material available if you could look at that.
that sounds good. I have a lot of respect for NARUC's legal staff.
And they have the NRRI Institute as well as a good resource. In fact, Dr. Peckman came down and interviewed with us. Do you know him?
I monitored the proceedings.
Good. So I thought he had, while we didn't choose him or his institute, I thought he could be a valuable resource. So
He's outstanding.
I would
He was
encourage him.
also on this Blue Ribbon Task Force that I worked on.
I'm sure he'd be more than happy to be a resource if you feel like you need to check in. But thank you again for coming. I appreciate your work.
Mr. Chairman,
Mr. Hamilton.
happy to have you with us today.
Thank you.
As hearing the conversation as we've moved along, we have 5 items that are facing us.
Correct.
I would think that possibly we need to narrow it to the ones that are must first and then move forward. I don't think getting all of it at one time is going to be a good thing for us. I think we need to take it one step at a time and start with must and move on to the lesser demand.
I appreciate that guidance. I know your timelines are rough, and so that will help.
Well, we've got a full schedule as a commission that besides this, so anything we could do like that, and if you could maybe, it would probably help you to intensify on one subject and then move to the next one. I know some of them are related, but we're going to have to solve them one at a time, I think.
Thank you. That's helpful.
Thanks, Commissioner Hamilton. Anybody? Commissioner Whitfield?
Chairman, thank you. Ms. Miller, good to have you with us. I know you said you didn't focus a lot on past procedures and past ways we've operated here in South Carolina, but you did mention the IRP process, and I know Judge Irvin went slightly there for just a second, but on the IRP process, in the past, we've just accepted that as information and haven't had any real authority there in the past, but you did use the word authorized this time, and you cited 58-37-40C, I believe, where the language you used in that statute used the word authorized. So now, I guess for the first time, the South Carolina Commission is authorized to actually hold a proceeding and issue orders and have some say in that process. And my question to you is, the other states you mentioned that you have observed, primarily here in the Southeast, I believe the Carolinas and Florida and Virginia, maybe Georgia, and are you seeing that our IRP laws now under Act 62 are more in sync with not only those southeastern states you mentioned, but maybe also other states across the 50-member NARUC states?
And I am only so far looking in the southeast.
Yes, ma'am.
But I know in Florida we have a 10-year site plan statute, and this does seem similar to me to what I've seen in Florida.
So Florida has the full authority, which is what I've always understood Florida to have.
Correct, and their language is, let's see if I have it handy here, but that's right, they have a statute. They do this through a workshop and then an internal affairs. So I just want to make sure I give you the right language on that. And in Florida, they very carefully say it's non-binding on future decisions. Their emphasis is that it is a plan. But they find it, I found the language, they find it suitable. They find it suitable. So your language.
They issue an order finding it suitable or not suitable.
Right, they do it through a report. But what I will do, because of your all's questions, is I'll focus real precisely on that.
Well, this does appear to give us much more authority than we've ever had, at least since I've been here. This gives the South Carolina Commission, because you use the word authorized, so this is, something we've not had in the past. Thank you. That's all I have, Mr. Chairman.
Thank you. Commissioners, anyone else?
I have one last question.
Yes, sir.
For Ms. Miller, you referenced, you were you were answering a question, and you used the phrase considering the legislative intent. In your opinion, what is the legislative intent of the statute?
Well, I listened to your proceedings, and I heard Commissioner Belzer read it a number of times, but let's see if I can go to it. Let's see. Page 7 of my law here. Okay, let's see if I can find what I'm looking for. Is that where I want it? There's legislative intent in a few places. In section 58, 4105, it starts off with some intent. The commission is directed to address all renewable energy issues in a fair and balanced manner, considering the costs and benefits to all customers of all programs and tariffs that relate to renewable energy and energy storage, both as part of the utility's power system and as direct investments by customers for their own energy needs and renewable goals. The commission also is directed to ensure that the revenue recovery, cost allocation, and rate design of utilities that it regulates are just and reasonable and properly reflect changes in the industry as a whole, the benefits of customer renewable energy, energy efficiency, and demand response, as well as any utility or state-specific impacts unique to South Carolina, which are brought about by the consequences of this act. That's one place where there is the legislative intent that I've noticed. And then I found some more in section 58-40-20. And here it says, it is the intent of the General Assembly to build upon the successful deployment of solar generating capacity through Act 236 of 2014 to continue enabling market-driven private investment in distributed energy resources across the state by reducing regulatory and administrative burdens to customer installation and utilization of on-site distributed energy resources. And it continues to avoid disruption to the growing market for customer-scale distributed energy resources. And it continues, and require the commission to establish solar choice metering requirements that fairly allocate costs and benefits to eliminate any cost shift or subsidization associated with net metering to the greatest extent practicable. So what I've noticed in your act is continuing, as I've seen in Florida, that you still have a balancing act. And even though it may move it a slight direction, there still is the balancing act that's been the tradition.
Which direction is it moving in?
Well, in my view, when I read this act the first time, I thought it was so pro-renewables.
And when you read it a second time?
And I still do.
Thank
Thank you, ma'am.
you. Commissioner Howard.
Glad to have you with us.
Thank you.
A couple questions. The states you dealt with, and any of them, and I'm sure North Carolina did at one time, have a renewable portfolio standard you had to deal with?
Well, yes, I did notice, I think that is the state, North Carolina, that I have written up. But in Florida, I don't know if you heard, but we had a statute for a renewable portfolio standard. And it was required the commission to do a rulemaking. And it was a very large proceeding, and we held this very lengthy, elaborate, involved all the stakeholders, and we developed a renewable portfolio standard. But you may not have heard that there was one, and what happened was it required ratification by the Florida legislature, and they did not ratify it.
Well, along with the renewable what about decarbonization? Are there any states you dealt with had any decarbonization goals?
So far in my review, I have not seen that. Not to say it doesn't exist, but I haven't seen
I'm just
it.
curious. That's fine. Thank you.
Thank you. Commissioners, any other questions? Ms. Miller, thank you. I hope this has been helpful to you. It's been helpful to us, and we'll look forward to hearing more.
Thank you very much.
Thank you. Mr. Menges, any?
Chairman, that concludes today's agenda.
Okay, we do have a transportation hearing immediately following this, so if there's nothing else for this part of our business meeting, we are adjourned. We'll continue with the transportation hearing in a few minutes.